Welcome to the People's Law School, best kept secret around. I want you to know that the Alabama Association of Justice, which was formerly known as the Alabama Trial Lawyers, has been presenting this program since 1985. This is an educational program, and we present to you the best lawyers in America. I want you to know tonight is no exception. We have Mark McDaniel, who is, without a doubt, maybe the very best criminal lawyer in Alabama. He has represented high officials, low officials, even the governor. I want you to know that if they're really in trouble, they hire Mark McDaniel. And too bad for them, but I want you to know it's a compliment to the lawyer. And I say it somewhat in jest, but Mark McDaniel has been a leader in every respect, and particularly in the criminal courts of this city. He has won every honor and accolade that I believe you can have in our profession. I always smile. I think the best compliment may be that he's a member of Mensa. Do y'all know what Mensa is? Mensa is, it means that you have been certified, I guess, as a genius. And Mark actually is in that club. I've never taken the test, but I want you to know he's in it, and he does a good job. He teaches, in addition to his law practice, he teaches at Faulkner University, the University of Alabama in Huntsville, Jones School of Law, the Birmingham School of Law. He has spoken at many commencements, and if that were not enough, I will tell you, and all of you know this, he has tried maybe 100 criminal trials here in Huntsville. He has had people, he has gotten people off of death row. He has done as serious cases there is. In fact, I told Mark one time, I said, Mark, I salute you. I don't see how you handle these criminal cases. He said, oh, that's nothing. He said, you know, in a murder case, he said the best witness is dead. I'd never thought of that. I'd never thought of that, but Mark pointed that out to me. But his firm has grown, and there's several lawyers in it now, and they're concentrating as well on civil actions. And in fact, he has filed 21 lawsuits for the Lee High School students who were killed or injured in the bus disaster that occurred last year, for your information. Along with, if that were not enough, Mark has received NASA's highest public service medal for his leadership, dedication, and counsel to America's space agency. This is just what he's done last year since he spoke to us last year. He is a senior advisor for the aeronautics and space issues to Congressman Bart Gordon, who has been named the chairman of the United States House of Representatives Science Committee, and Congressman Gordon appointed him his senior advisor in that regard. For your information, Mark McDaniel has met twice last year with the President of the United States regarding NASA and other space-related issues. He has also been named Vice Chairman of the Board of Directors of the Huntsville-Madison County Airport Authority. And I tell you all this to simply let you know that he's not really the brains behind the outfit. Henry McDaniel, his wife, who is seated over here, she's the second one over here to my left. Henry McDaniel has been his law partner, his wife and law partner for almost 35 years. And seated with her is their daughter, Henry Jo Hestowski. By the way, Henry Jo has a master's degree, but she also works in the firm as a litigation coordinator. Her husband, Marcus Hestowski, by the way, is a lawyer there, as is Ben McDaniel, their other child. And they also have two grandchildren whose names are Daniel and Anna Grace, and so the McDaniels are mighty busy people these days. And it is an honor and a privilege, I want you to know, for me to present to you tonight my friend Mark McDaniel. Thank you so much, Mark. Thank you.
It's always an honor and privilege to be with you here at the People's Law School. I have done this program for many years, and you couldn't have a better moderator or a better person to be with you every week than Alan Brinkley. He's a great lawyer and a true friend of mine. I did a talk about a month ago, and after I got through this, I guess this little boy was about 5 years old. He came running up to me and he said, "Sir," he said, that sure was a boring speech. And he said, you know, I think some people even went to sleep listening to it. Well, his mama come running right up, that thing. She said, oh, my Lord, Mr. McDaniel, I'm so sorry. He's at the age where he repeats everything he hears. I'm reminded of the preacher who gave a sermon. He worked 2 weeks on the sermon, worked so hard on it. And he gave it, and he all got through, you know how they get at the door and shaking hands with people when they're leaving. And this little girl, she come up to him and she put her hand out, and she had a nickel in it. And she said, I want you to have this. And he said, well, okay. He took it. He said, but what's it for, little girl? And she said, well, my daddy said you was the poorest preacher he ever heard. I like to tell this a true story that I first was appointed to the NASA Advisory Council by President Clinton, and was appointed twice by President Bush. And I served with Senator John Glenn, served 3 years with Senator John Glenn, Senator Jake Garn, who also went up in space, I served with him, James Cameron, who wrote, produced, and directed Titanic. Served 3 years with him on the NASA Advisory Council. Richard Danzig, former Secretary of the Navy. Freeman Dyson, Nobel Prize winner from Princeton, served 4 years with him. I served 5 years on the NASA Advisory Council. So I had the opportunity to serve with some great, great Americans, and I'll refer to them as in some of the issues that we cover. I can refer to some of these great people. But I will tell you about when my first appointment, when you get a presidential appointment, the first person that will call you and tell you that you're a congressman. So I got the call from the congressman. Congressman Kramer called me up and said, you're going to be getting a call from the president naming you to the NASA Advisory Council. And I said, okay, I really appreciate that. So I buzzed Carmen down and said, wait, the president's going to be calling. So it was about 15 minutes later, the president called and congratulated me on the appointment, and congratulated me on the appointment. Short conversation with the president. So that was very exciting. And then hung up, and probably, well, you know, it wasn't 2 minutes after that. Carmen buzzes me and she says, Mr. McDaniel, she said, Time Magazine's on the phone. I said, okay. You know, so I got my legal pad, pencil, ready for the interview for Time Magazine. So he said, on the phone, this is Mark McDaniel. The person said, yeah, well, this is so-and-so from Time Magazine. I want to let you know your subscription has expired. And, I'll talk about that a little bit later on tonight, too, about being humble. Okay. The Lord has always took care of me. I've been practicing law 31 years, and I'll talk about this a little bit later on, but every time, that I do something and get to thinking, well, it's pretty good. The Lord takes care of me that way, But anyway, my topic tonight is criminal and civil litigation. Well, you start off with knowing that there is a difference between a civil case and a criminal case. That's obvious. Some people don't know that. Some people think that everything's the civil case and criminal all the same, but they're different, totally different. The best example is the O.J. Simpson case. If you remember that, I think that's a very good teaching too. There was a criminal case where he was indicted and charged with murder. He was found not guilty of that. But there was another case after that, this is called a civil case. And that's where a lawsuit was filed against him, okay? And he had to go to court in the civil case. And he was sued for money, okay? And he lost that case. They got a big judgment against him. So we'll kind of use that case a little bit to go by in this class, and in some other cases, to tell you that there is a difference. And people need to know that and understand that, because you can have a situation where a person can be charged with a crime, and also there be a civil case where the person, if you're a victim of a crime, you can sue the person that did something to you. So you've got two ways to go out there. If you've got your outlines there that was passed out tonight, you see I just give you a definition there of civil law and criminal law, and it just says civil suits relate to and affect only individual rights, whereas criminal prosecutions involve public wrongs. And I give you a definition there of the criminal law and criminal proceedings. Criminal proceedings, if you look at that, one instituted and conducted for the purpose either of preventing the commission of a crime or for the fixing the guilt of a crime already committed and punishing the offender, as distinguished from a civil proceeding, which is a redress of a private injury. Okay? So we've got the criminal law over here. If you go to law school, you'll take a course in criminal law and a course in criminal procedure. And the criminal law is where society says, or the state of Alabama, or the federal government says, this act is a crime. If you do this, we will punish you. As a society, we say it's wrong. That's a criminal case. If you do that act, if I go out here tonight and I drink some alcohol before I leave the building, and I go out here and run a red light, and somebody's killed, I'll be charged with murder. Well, that's the crime, isn't it? I can be put in jail for that, can't I? That's a crime. Can the family of the deceased person, can they file a civil lawsuit against me? They can, can't they? So you can have two things going. Now there's a difference, and a basic difference in a civil case and a criminal case, and that's what we're going to talk about some tonight. We have different definitions there: jurisdiction, venue. I'll talk about that just some more in just a minute, though. The burden of proof. If you look there on your outline, you're going to see three different burdens of proof there. Okay. Burdens of proof. Now this is very important. Burden of proof, because it says this. You see where it says preponderance of the evidence. That means the greater weight of the evidence. Okay. And you see clear and convincing evidence, and that clear and convincing is defined as more likely than not. Okay. And then you got beyond a reasonable doubt. Some judges have defined that as a doubt for which a reason may be given. Now, the importance of that is that the preponderance of the evidence, that's the burden of proof in a civil case. The burden of proof in a civil case. If I sue somebody, if I'm your lawyer and I file a lawsuit against them for negligence, we'll talk about that in a minute too. If I file a lawsuit against them for negligence, then what I have to prove to a jury by the facts from the witness box is I got to prove a duty of care, a breach of the duty of care, and an approximate result of that somebody was injured. That's the elements of negligence that's in your outline we'll get to in a minute. But that's what I got to prove. That's how you prove a case. So if you come to a lawyer and you have a lawsuit and you want to sue somebody and it's for negligence, or it could be breach of contract, whatever, there'll be elements that you have to prove. What I just told you there is a negligence cause of action, okay? So if you come to me, you have a negligence cause of action, or Alan or another fine lawyer in this town or this state, they got to go to court, put people on the witness stand to prove those facts, those elements. Number one, duty of care. If it's a negligence of a car wreck case, duty of care, breach of duty of care, breach of it. That means, let's suppose that I'm saying the other person hurt my client, was intoxicated, and ran a red light. Well, I got to prove that, don't I? I can't just say it. I can't just get up in front of a jury and say, let me tell you what happened. No, I can say it, but I got to prove it. What comes from the lawyer is not evidence. You got to put the witnesses on there. So you get duty of care, breach of duty of care, breach meaning I got to prove what I said in the complaint. Now, what is my burden of proof in the civil case? A preponderance of evidence. There, you see that? A preponderance of the evidence. The greater weight of the evidence. Have you ever seen this? I always tell a jury, explain it to a jury. Have you ever seen the lady with the scales of justice? You ever seen that? Okay. She's holding the scales of justice. Okay. A preponderance of the evidence is tilting the scales ever so slightly. So if it's a civil case and I'm suing for money, then I have to prove the case to the jury by a preponderance of the evidence, the greater weight of the evidence. The other side to put on a case, they'll put on evidence, but if my case tilts the scales of justice, then I should prevail. I prove my case. Now the issue would be how much money then the jury would find, but I got to prove my case before I got to worry about money, don't I? I got to prove that by a preponderance of the evidence or a greater weight of the evidence. Okay, now, look down at number C, beyond a reasonable doubt. Okay? In a criminal case, in O.J. Simpson's case, in the criminal case, before he could be convicted, before your liberty and your life can be taken from you in America, the government has to prove their case beyond a reasonable doubt. Used to be, when I first started practicing law in 1976, it was beyond a reasonable doubt and to a moral certainty. But you can't say moral anymore. You can't say that. You can't. You can't say to a moral certainty. It's beyond a reasonable doubt now. The courts have said you can't say the word moral certainty anymore. So anyway, so the government, before your liberty, before your freedom can be taken from you in a criminal case, the government has to put witnesses on to prove whatever they charge you, murder, arson, burglary, DUI, whatever the charge is, they got to prove that case beyond a reasonable doubt. Now, let's go back to our scales of justice. All right? That's like this. Okay? That's not tilting in a civil case. Remember in the civil case, O.J. Simpson lost it. The burden of proof in the civil case was not as great. The burden of proof in a civil case is a preponderance of the burden of proof in the criminal case is beyond a reasonable doubt, because in our country, in our nation, our government, our Constitution says a person's liberty, a person's freedom, a person's life before the government can take it. That's more precious than money, according to our rules, according to our Constitution. Therefore, the burden of proof is greater in a criminal case than it is in a civil case. Okay? Now, so that's one big difference in a criminal case and in a civil case, the burden of proof. Okay? Now, another thing that's different in a civil case and a criminal case, and we'll look at that in a little bit more, is called discovery. All right? Now, discovery is this. Discovery in a civil case, I can have people come into my office and give depositions. You ever heard of a deposition? I can send interrogatories. That's questions that I propound, send to the other side, and have their clients answer those questions, called interrogatories. I can file motions to produce. I can do all kind of, there's all kind of what you call discovery in civil cases, okay? Not so in a criminal case. Suppose you are a witness to a crime, not a civil case, but a crime. Suppose you are a witness to a crime, and I come to your door and I say, Mr. Johnson, I understand you as a witness to a murder case, and I'm defending somebody, this person in it. Mr. Johnson says, yes, I was a witness. Well, do you mind, could I talk to you about it? Mr. Johnson says, no, I'm not going to talk to you about it, and get off my porch. You know what I got to do? I got to get off Mr. Johnson's porch. That's it. That's all. I'm going to hear what Mr. Johnson's got to say about that case when Mr. Johnson takes the witness stand in the criminal case against my client. I don't care if the state's going for the death penalty or what. That's the first time I'm going to get to hear Mr. Johnson. Right then. Okay? That's it. Now I can file, what you call a Brady motion, a motion for exculpatory evidence. Now I've got people off death row on this issue, where the state has evidence in its possession that may tend to clear my client. The government has something in their file that could exculpate, that could clear my client, and I file a motion for that. The government's got to give it to me. Now the problem is, they don't give it to me. How am I ever going to find out that they got it? That's sometimes you do, and sometimes it's after your client's on death row. But if you find that the state had it and didn't give it to you, then you can get the case reversed and get a new trial and get that evidence in the second trial. I've done that before, and got the person got convicted, put on death row the first time around. I found out that the government had evidence, and they didn't give it to us. We found out about it. We got it. We had another trial. The case got reversed. Got another trial. And the man was found not guilty. We served 5 years on death row. But that's the extent of my discovery. I can't make you talk to me if you're a witness to a crime. Now, what if you're a witness to a civil case, a car wreck? I come to your house, knock on your door, Mr. Johnson, I understand you're a witness to this car wreck, and I'm filed a lawsuit on behalf of the person that got hurt. I'd like to talk to you. And Mr. Johnson says, I'm not going to talk to you. Get off my porch. And I'd say, yes, sir. But before I get off your porch, here's a subpoena to be in my office at 9 o'clock in the morning to give a deposition. And if Mr. Johnson don't come, I'll have a deputy sheriff go pick him up and bring him to my office. Mr. Johnson's going to come to my office and going to give a deposition. And I'll have a court reporter there, and I'll put Mr. Johnson under oath, and he'll testify. If he says I'm not going to testify, the judge will encourage him to testify. That's in civil case. In a civil case, there's no excuse for you not knowing everything about your case, because you got all these motions. Like I said, you can file interrogatory, you can file motions to produce, what you got, tax record, whatever. You can file all these motions, but not in a criminal case. Now, the burden of proof is higher in a criminal case, but the discovery is a whole lot better in a civil case, depending on which side you're on there. If you look at, so that's this clear and convincing evidence, the burden of proof there before we leave burdens of proof. You see that in an insanity defense. I've had a number of cases where insanity defenses was an issue. Most recently, that was an issue in the young lady that I represented that was charged with starving her 3 children to death in our city here. That was an issue in the case. There are 2 things, though, before we leave that. 2 things, though. The only time the defense has a burden of proof in a criminal case. This is very interesting, by the way. In a criminal case, the defendant does not have a burden of proof. The defendant, and that's another thing, we're going to talk about in a civil case, the difference between a civil and a criminal case. In a criminal case where the government charges you with a crime, or the state charges you, the government has the burden of proving each element of the charge beyond a reasonable doubt. The government has that burden of proof. Okay? The defense does not have a burden of proof. In a criminal case, the prosecutor cannot call your client to the witness stand. The prosecutor cannot call the defendant to the witness stand. The prosecutor can't even comment to the jury. If the defense does not put the defendant on the witness stand, if the prosecutor cannot even comment to the jury about that. The prosecutor can't say, well, ladies and gentlemen, I know there's one person in this courtroom that could tell us what happened out there in this homicide, but he didn't testify. The lawyer's going to jump up, judge, objection, ask for a mistrial. Judge's going to say, granted, mistrial. The prosecutor cannot comment about that, okay? Now, in O.J. Simpson's case, did O.J. Simpson testify? No, in the criminal case? No. The only human being in the world that could have put O.J. Simpson on that witness stand in his criminal case was O.J. Simpson. Because, and nobody could ask him any questions, because he could take the Fifth. There we go, take the Fifth Amendment. Heck, I refuse. If I have, a lot of times I'll have a client that's subpoenaed to testify before a grand jury, and I have a little card for them to read. And they're supposed to go by this. Sometimes they don't. They're supposed to. But this little card says, I respectfully decline to answer this question on the ground that it may tend to incriminate me. And that's all they're to say, but you haven't given their name. Okay? They plead the Fifth. But in the criminal case, the defendant cannot be put on the witness stand by the prosecution. In a civil case, put our civil hat on now, in a civil case, the O.J. Simpson case, who did the deceased family, their lawyers, who did they call to the witness stand? O.J. Simpson, because they had some questions to ask him. Okay? And Alan will tell you this, any good lawyer will tell you this, in any case, your client, we'll talk about that when we talk about trials in a minute, that's the one that you kind of worry about the most. How are they going to do? Okay? But in a civil case, in the car wreck case, and let's say I'm representing a person and we've sued somebody in a car wreck case. You know who my first witness can be? I call the defendant to the witness stand. I can do that. Not in a criminal case. I cannot put the person on the witness, but I can in a civil case. Okay? And use that person against themselves. Sometimes that's the best witness in the case there. So those are really big differences in the criminal and in the civil cases. Crime and tort in your outline, I got crime and tort distinguished there. We've talked about that already to some extent. A crime, again, is a positive or negative act in violation of the penal law, an offense against the state. And then we got tort, a private or civil wrong or injury, a wrong independent of contract. And there are 3 types of torts. If you see in your outline, intentional torts. Now, an intentional act is if I walk up to you and I hit you and I break your nose, you can get me arrested for that. It's assault. But you can also sue me for that. Okay, so there's a criminal case and a civil case. All right, because you got the assault. Then would that be an intentional tort or a negligent tort? Intentional. That's not. There's nothing negligent about that. That's intentional. If I take you by the arm and put you in a closet and lock the closet, false imprisonment. That's kidnapping. It could be the crime would be kidnapping, but the civil would be false imprisonment. Did I do that negligently or did I do that intentionally? If I pull out a gun and shoot you, boom. Would I get? Certainly that's a crime and I can get prosecuted for it, but I can get sued for that too. Okay, and that would be an intentional tort. Intentional. What about this? What if I don't have a gun in my pocket? Couldn't have got through the thing out there. But anyway, suppose I had a gun in my pocket and I pulled it out and I'm drunk. And I look here. This is People's Law School. And I just want to show you an example of a gun. Look, boom. Oh, it went off. And I fall down and start crying, but somebody's dead. I didn't intend to do it. I was reckless. Okay. In the criminal part there, like I told you about the alcohol a while ago, there's 3 ways you can be charged in Alabama with the reckless act like that, or the DUI. If I go get intoxicated at night and leave here and kill somebody, I didn't intend to kill them. There's no, but I'm gonna get charged with murder because 13A62 of the Code of Alabama says in Alabama there's no first degree, second degree murder, first degree, second degree manslaughter. That's Tennessee, Georgia, not Alabama. Alabama, you got murder, manslaughter, and criminal negligent homicide. Okay? And murder is defined in 13A62 2 ways you can commit crime of murder in Alabama. It says a person commits crime of murder if they intentionally cause the death of another person. The second way you can be charged with murder in Alabama, it says a person can be charged with murder if under circumstances manifesting extreme indifference to human life, they recklessly engage in conduct which creates a grave risk of death and the death ensues. The word reckless, the definition of reckless in Alabama is where a person is aware of and consciously disregards a substantial and unjustifiable risk that the circumstances of this or result will occur. There's another statute right after that says you cannot get out of the awareness requirement by saying, oh, I was drunk. The law covers that. You can't say, I wasn't reckless because I was drunk. I couldn't be aware of. Now, there's a statute that covers that, okay? By the way, what I said to you, that's just what a jury hears. So if you're a little bit confused, that's what they hear. The judge can't get up there and lecture the jury. The judge tells the jury the law, okay? And in my world, words may mean something in one case and something in another case, depending on who the jury is. We'll talk about that a little bit more in just a minute too. Words. What is reasonable? What is reasonable doubt to you may not be reasonable doubt to somebody. What is a preponderance of evidence? It's a greater weight of evidence. It's the lady with the scale. Come on, lawyer, do better. Put it on the board. Man, we can go, this community, we can go to the moon on mathematics and physics. You've got to do better, lawyer. Put it on the board. Can't do it. A reasonable doubt. A doubt for which a reason may be given. Preponderance of the evidence. Greater way there. Recklessness. Under circumstances, we already murder. Could I be charged with murder if I leave here and get drunk and I run a red light and kill somebody speeding? Yes, 13A62. Manslaughter, let's go 13A63 and see what could happen there. Manslaughter, it says a person commits a crime of manslaughter if he intentionally caused the death of another person, but he does so due to a sudden heat of passion caused by provocation recognized by law. Well, that's 2 guys at a bar, and one of them, for example, I look at that pretty young lady right there. Just came in, it wouldn't be that way. Y'all know I can't say it on TV. Look at that pretty young lady that just came in the bar. And the other guy said, well, that's my wife. And the guy said, well, I don't care if that's your wife. She sure is a good-looking lady. Boom, knocks him off bar stool. Guy comes up and sticks him with a knife. He intended to kill him, stuck him with a knife. but he did so due to a sudden heat of passion caused by provocation recognized by and the only thing can be provocation in Alabama is an assault. Words, no matter how insulting, no matter how opprobrious, no matter how bad, can never reduce a charge from murder to manslaughter. A person can dog cuss you, and if you kill him for it, it's murder. It's not manslaughter. You can never reduce it from murder. Words can never reduce it. It has to be an assault or catching your, I won't go into this very much detail, catching your spouse in the actual act of a bad relationship with somebody. not leaving the bedroom, but in the act. That could reduce it from murder to manslaughter. If it's not temporary insanity, it would reduce it from murder to manslaughter. Back to our intoxication, okay? 13A62, all right, another way you can be charged with manslaughter is as a person commits crime of manslaughter if they recklessly cause death of another person. And you said to me, lawyer, you just said a while ago that was murder. No, 13A62 said, under circumstances manifesting extreme indifference to human life, he recklessly engaged in conduct, which creates a grave risk of death and a death ensues. That's 13A62. 13A63 manslaughter says a person commits a crime of manslaughter if they recklessly cause the death of another person. And you say, well, is the definition of reckless the same for murder and manslaughter? Yes, same. Aware of and consciously disregarded, substantial, same definition. Okay? So, could I be charged with murder, leave it here, get drunk, kill it, but could I be found guilty of manslaughter? Not guilty, could I? Yes. Now let's talk about 13A64. It says this, a person commits a crime of criminal negligent homicide if they cause the death of another person due to criminal negligence. Well, what's the definition of criminal negligence? Where a person fails to perceive a substantial and unjustifiable risk that a circumstance exists or a result will occur. The only difference between reckless and failure to perceive is reckless where you're aware of and conscious disregard. Criminal negligence where you fail to perceive a substantial and unjustifiable risk. So, could I be found charged with murder but found not guilty of murder, not guilty of manslaughter, and guilty of criminal negligent homicide? Give me a nod. That could fit there too. Okay? So, after going through all that, is it important how the lawyer does in front of the jury? Is it important how well the witnesses are prepared and how well the witnesses do in front of the jury? Do you want your client when they come in and they got a t-shirt on and their cigarette here and the tattoos all over their arm? Do you want that? You tell your client, you don't ever overdress, you know, but don't come in looking like you're going to a nightclub, But sometimes it works, sometimes it don't work. They don't listen to you. We'll talk about that again in just a minute too. But these are words, aren't they? And it's up to again 12 people what they decide on the issue. I've got your Alabama criminal procedure there, your procedure that you go through, and I will just briefly go through that because I want to get to this to a lot of the trial part because this is called litigation. I'm trying to give you a little bit of idea what this is like in the courtroom. And I have you right down where it says General Rules of Evidence, where it says number 8 there. If you have an outline, it says General Rules of Evidence. Direct evidence proves a fact without inference. Circumstantial evidence is evidence from which a fact is reasonably inferred but not directly proven. Circumstantial evidence is suppose you go home tonight and you look outside, you go outside, and there's not any snow on the ground. But you wake up in the morning, go out at 6 o'clock in the morning, snow all over the ground. You walk out, look around, and there's rabbit tracks across the snow. Did you see it snow? No. Did you see a rabbit hop across the snow? No. Did it snow? Did a rabbit hop across the snow? It did. But when they, and that's always the example used in the courtroom, but I always stand up in front of the jury and say, ladies and gentlemen of the jury, it snowed. And a rabbit hopped across the snow. But they didn't prove that rabbit hopped across the snow. Anyway, that's what you got to think. Anyway, but anyway, that's direct and circumstantial evidence. That's how those are ways you prove a case. Function of judge and jury there. The jury is a trier of the facts. The judge tells the jury what the law is. The judge is like a referee. The judge there will rule on evidentiary matters and will decide what the law is and tell the jury what the law is there. Function of judge and jury. Relevant evidence there, evidence that has any tendency to make the existence of any fact that is of consequence to the determination of the action more probable or less probable than it would be without such evidence. Weight and admissibility, that's important because the judge can decide admissibility. The judge can decide if a jury hears something. Suppose your client has confessed, but the reason she confessed is because she said, I confessed to the drugs or the burglary or the murder, whatever, but they told me that they'd set my bond at $1,000 and I could go home to my 3 kids, but if I didn't confess, they would go no bond me. So I'd confessed. And the judge allows her confession, where confession says, I did the killing, or I was with somebody, whatever. So the jury would get to hear that the judge rules on admissibility, and suppose she got her Miranda rights given to her and so forth and so on. And so the jury gets to hear that. They get to hear the confession. But it's up to the jury to determine how much weight they give it. The judge can allow it, but the jury decides how much weight they're going to. And if the jury can say, okay, I heard it, but I ain't buying it. That means, I believe her that she didn't do it. She just said anything to get back home to them children. Okay? So that's what that weight and admissibility talks about right there. Of course, you get your rules on your rulings on evidence, objections. Let me very briefly tell you what that's like in the courtroom. What's going through for a trial lawyer. You got a witness on the witness stand, and a question's asked of that witness on the witness stand. Okay? What's going through my mind when the other lawyer, when my opponent asks the question, what's going through my mind is, do I object to the question? Okay? Now, then the person starts answering the question. Okay? What's going through my mind at that point is, do I object to the answer? Okay? Now, if I don't object to the question, don't object to the answer, I better be taking notes about what I'm going to ask that witness about on cross-examination. That's for every question. I tell young lawyers that people want to go to law school, you need to have a pretty be kind of healthy. You don't need to have a whole lot of bad habits, because if you're in the courtroom, if you're going to make your living in the courtroom, you got to be with it. Okay, you can't have a bad morning, or you can't if you're a morning person, or I'm an afternoon person. Well, if your opponent knows that, when are they going to put their main witnesses on? Okay, you're not going to be. By the way, don't go. The other lawyer asks a question. Wait a minute before you answer it. Mr. McDaniel might want to object to my question, and answer real slow, because he might want to object to your answer. And answer real slow, because he's trying to take notes over there. Does it work that way? It's boom, boom, boom. If the lawyers are prepared, boom, 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 boom. That's what it is. It's quick. And not only have you got to object, you've got to state your grounds. Objection, Judge. Objection. State your grounds, Mr. McDaniel. Well, I just sounded bad to me, Judge. No, you got to know your rules of evidence. Objection. State your grounds. State your grounds, and he'll sustain it, or she'll sustain it, or she'll overrule it. But that's not in the law books, but that's how it is in the world. It's quick, and you got to be on your toes. Let's look here. Examination of witnesses. Cross-examination there. We'll look at that real quick. That is the best tool that any lawyer has, is cross-examination. The best tool is cross-examination. And people say to me, how in the world do you cross-examine, do such a good job cross-examining people? Okay? Because you get a lot of experience when you're a child cross-examining. If I do something wrong, my mama would ask me, did I do something wrong? And sometimes I'd say, no. And she'd cross-examine me. she'd cross-examine me. My first grade teacher, Miss Tanner, she said, Mark, I always tell my class at Faulkner, I got some of my UH graduate students in here tonight and a lot of my Faulkner students here tonight, and I always tell them when I pass the test out, I always tell them what Miss Tanner told me. And I don't know why she told me this, but she said, Mark, she said, I want your work, not your neighbor's. Anyway, if you do it, you think about that, you know. Anyway, you cross-examine people every day. You're supposed to be home at 7 o'clock. You know, why wouldn't you here at 7 o'clock? That's not my perfume. You know, whatever. That's not, that lipstick. I went to People's Law School and somebody hooked my neck, you know. Anyway, you can get, especially if you got a wife or a lawyer, you can get cross-examined. Okay? But that is the greatest tool that you have. The greatest tool you have is cross, and everybody can do it. You just have to do it. You just have to. So many people that would be great lawyers, they don't do it because they're afraid they'll look bad, or they're afraid, oh, I just, you know, I might make a fool of myself. Well, you might, you know, but then you might do good, you know. But a long time ago, a lawyer told me this. He said, look, Mark, he said, a timid lawyer is more dangerous to his client than a rattlesnake. If you sitting there next to your client and you timid, you're dangerous to your client. You got to be at it. I got to tell you a story before I move on. Y'all remember Mr. Jeff Smith? Mr. Jeff Smith, I love Mr. I learned a lot from Mr. Jeff Smith. When I came in town, I was 24 years old, 1976. Mr. Jeff Smith was about to retire. And I went to his office, talked to him about a case, asked him to get his advice. And when I went to his office, he had behind his desk, he had a big old stuffed big mouth bass. You know what I'm talking about. You ever seen a big old big mouth bass? They got them now in the store to talk. You know, they sing and everything. But back in them days, they didn't. He was only in a big old mouth. He had a sign on it and said this: if he'd have kept his mouth shut, he never got caught. I remember that. That's helped me a lot in my practice of law. All right. So anyway, that cross-examination is so very very important. And again, you actually win and lose your cases on that a lot of times. Is cross-examination. All right. If you go, let's go here to the jury trial real quick here. We've talked about the rules of evidence there a good bit there. Jury trial, the first thing it talks about voir dire there, and that's questions you ask prospective jurors. If everybody was in this room and you were on a panel to decide whether or not you was going to be on a jury, there'd be 12 people would be picked from this room, 12 people, okay? The lawyers get to ask everybody questions. That's called the voir dire. You get to ask some people questions, and that's very important. You know, you get a feeling about what people think about things. Now, you don't know who the 12 people are going to be on that jury. The state don't know who they are. People ask me all the time, am I going to win my case? And I don't know. Well, wait a minute, what do you mean you don't know? Can you tell me what kind of jury we're going to get? Can you tell me? They can't know, nobody in the jury can know me, and I'll make sure they don't know the other side. So, you know, no, I mean, what a person will do themselves is psychology. What they'll do with 11 other people is sociology. And what people might do with another group of people, who knows? I know this, that if this is a capital case, the judge, before we even got to talk to you, would ask, is anybody in this room that's opposed to capital punishment? And if you raise your hand, where are you going to go? Home. You get to go home, don't you? And then the people left is, I'll kill him. Okay? And that's fine, that's it, you know? That's what you know, so you go from that point. By the way, in a capital case, the jury, if they find your client guilty, that very same jury will recommend life or death. The very same jury, okay? Then the opening statement there, of course the opening statements, again, there are lawyers that say that's the most important part of the trial. It's a roadmap. That's where the prosecution gets up and says what they expect the evidence to show. The defense gets up and says what they expect the evidence to show. Again, different lawyers will say this part's the most important, and I've heard all different theories. I think every part's the most important. I don't think you drop the ball. If there's some people say, well, after opening statement, it's done. You've either won or lost after opening statement. I don't think so. I think it's important. I think it's all important. I don't think until that jury comes back, everything is important in that case. The order of presenting the witnesses there, state goes first. The state has to prove a prima facie case. The state has to prove that this thing happened, or give enough evidence that it can go to a jury. Let's prove a prima facie case. The next thing is the defense can put a case on. It's a criminal case, they can, but you don't have to. Remember what I told you about? That the defense does not have to the defendant don't have to put their client on the witness stand. You can say the state didn't prove the case beyond a reasonable doubt, and that's it. You can rest on that. You don't have to put on any evidence. But if you do put on evidence, be prepared. And let me tell you something, folks. If you don't hear anything else I said, I have been with the most powerful people in this government. I have been in the governor's mansion. I have been in the halls of the mighty and the rich and the corporate people. I've been, and I've had the honor of representing the homeless. And there is no difference, by the way. They're human beings. They're human beings. But let me tell you this. Everybody that gets in trouble has a support group. And they've done something wrong, but they've gone home and they've talked to their friend or their husband or their wife or somebody so much that they got themselves convinced that a jury is going to believe this. Because the support group says, it sounds good to me. Yeah. Well, yeah, I stole that money, but, I didn't know I was stealing it. That's right. The jury will believe that. You got that support group, and everybody's loving you, and they kumbaya, and everybody, But let me tell you something. It ain't Sunday school, folks, in the courtroom. No, it's hardball. It's like that. With the presidential candidate Huckabee said, "This is presidential politics." He said, "It's hardball. It's hard." And in the courtroom, people are in there saying, "Well, let me make sure everything's all right." No, everybody's there to win. I've never been hired in 31 years. Somebody tell me to go lose. Never. They don't do it that way. And so your client comes in, they tell you this story, and they don't like it when you tell them that don't make any sense. What do you mean? It don't make no sense. My wife said it did. Well, go get your wife to represent you. That don't make any sense. So that's important. Okay, so listen, get you a good lawyer, listen to your lawyer, and and again, if the lawyer gives you bad news, then that's what you better to get it up front in it, as to we'll go to trial and get and everything's multiplied and everything's harder. You get down to the closing statement. I will. That's a whole another world. That's where you tell the stories, and that's where and I'll go into some stories here in just a minute, and some characteristics that I think is important for a lawyer, and I'll tell some of the stories that I tell in front of the jury there. You have your jury deliberations, of course. That's the hardest part in the world for a lawyer, jury deliberations. You waiting, there's nothing else you can do. You waiting, that jury's back there. You waiting that knock in that verdict, and that's tough. That's especially whatever case is tough. Capital case where somebody's life's on the line. Those are tough cases. They're all tough cases. They're all hard cases, but those are tough cases. But that's a tough time because you're out there. I'm out there prancing up, pacing. I'm bad to pace, waiting for that jury to come back. We got like 10 minutes left, and I want to go into a little bit now about some characteristics. And the reason I do this, folks, is because I've had so many law professors tell me to do it, because they want to know. So many young lawyers want to know what does it take? What do you think? What's important to you? This is important because these are things I look for in jurors. These things may help you if you're thinking about law as a career. good characteristics that could help you. Number one is this, and this is not lost, not in your outline, but again, I do this because I had so many law professors. Every time they played this back to some law classes, by the way. Do you know that? These lectures in the law classes, because this is where sometimes law students can learn how to be lawyers. Number one, it has been my experience in my 31 years of practicing law that most people are extremely judgmental when it comes to the shortcomings of others. But when they get in trouble, they don't want judgment, they want mercy. There is a book written, it was first published in 1888 by William H. Herndon, called Herndon's Lincoln. And Mr. Herndon, he practiced law with Abraham Lincoln 18 years before he was president. He knew a good bit about Mr. Lincoln. And he was talking to one of President Lincoln's best friends before publishing the book about whether or not he should publish a book. And this is in the preface of that Herndon's Lincoln, published in 1888. "There is but one true history in the world," said one of Lincoln's closest friends, to whom I confided the project of writing a history of his life several years ago, and that is the Bible. "It is often said of the old characters portrayed there that they were bad men. They are contrasted with other characters in history, and much to the detriment of the old worthies. The reason is that the biblical historian told the whole truth, the inner life. The heart and secret acts are brought to light and faithfully photographed. In other histories, virtues are perpetuated and vices concealed. If the life of King David had been written by an ordinary historian, the affair of Uriah would have at most been a quashed indictment with denial of all the substantial facts. You should not forget there is a skeleton in every house. The finest character dug out thoroughly, photographed honestly, and judged by that standard of morality or excellence which we exact for other men is never perfect. Some men are cold, some are lewd, some dishonest, some cruel, and many a combination of all. The trail of the serpent is over them all. Excellence consists not in the absence of these attributes, but in the degree in which they are redeemed by the virtues and graces of life." I think that's a pretty good statement there that was written from that book about Mr. Lincoln. Number two is remain humble, or as my grandmother used to say, don't ever forget where you come from. Mo Mack told me that. And I told you to start off, I've had the honor to serve in try some mighty big cases and serve with some great people, but you don't ever forget your humility. The most humble people I've seen in my life, one of them is Mr. Senator John Glenn. I got to know him real well by serving with him, and you talk about a humble, and some, again, you'd think, well, you know, these people are pioneers, but they're humble people. They don't go around talking about what they did. They really want to help other people. We'll talk about in just a minute. The only true happiness you will ever find is when you are helping someone. You can't be high and mighty. You have to have a humble heart. If you're an arrogant, uppity type person, figure out a different way to make a living. Don't try to do it in front of a jury. It's been my experience. I was fishing one time with my daddy in 1976, and we was at Gunnersville. I had just been to, I can't see the clock, but I have that glass on. I'd just been to Hammers, and I'd bought me I just started practicing law. 24 years old. Y'all know where Hammers is over in Gunnersville. And they had a basement down there where they had the fire, the smoke damage stuff, and I bought my clothes down there because I didn't have no money. And still got some of them suits just to remember, bought the white suit with smoke damage, but it was new. To me, it was new. And I had that red one still hanging up in the closet that was smoke damage. But me and Daddy was fishing. And it was about 8 o'clock. And Daddy said, "Well, son," he said, "reckon what all the poor people are doing right now." I said, "Daddy, I know what two of them's doing right now." You don't ever need to forget where you come from there. One of my favorite people in history is George Washington Carver. George Washington Carver was born in slavery. Because of what he did in his life, he changed the world with his research in soybean, cottonseed, and the different things that he did in his life. A lot of people don't know this, but Henry Ford offered George Washington Carver 6 figures to come and work for him in Detroit. And George Washington Carver decided to stay at Tuskegee and make $1,800 a year. But he changed the world there. At the end of his life, somebody asked Mr. Carver, what is the secret to your success? And this is what he said, and I've written this down. How far you go in life depends on your being tender with the young, compassionate with the aged, sympathetic with the striving, and tolerant of the weak and strong, because someday in life you will have been all these. And I think it summed up that great man's life real good. Sometimes attitude number 3, sometimes attitudes are more important than facts. That's sometimes some of the happiest, some of the people you think should be the happiest are the saddest, and sometimes the people you think are the saddest are the happiest. Sometimes you see people in terrible situations, but they have a good attitude about life. Helen Keller said, "Believe, no pessimist ever discovered the secrets of the stars or sailed to an uncharted land or opened a new heaven to the human spirit." Helen Keller. And if anybody had, look at her attitude, what she had. Last story I'll tell you. I was giving a law school commencement address at Birmingham School of Law, and one of the students asked me who the greatest lawyer was that I had ever heard of, and I told him I would tell him about that during the speech, and I thought I'd share that with you tonight. It's a man named H.D. Spafford. Mr. Spafford was a lawyer in Chicago. You've probably never heard of him. He had a son and he had 4 daughters. It was 1871, 2 years before the Chicago fire. His son died. Then 1871, the Chicago fire, he lost all of his holdings in that fire. 2 years after that, his wife came down with a sickness that the only place she could get treatment for that was in England. And so he put his wife and 4 daughters on a ship to go to England. At the last minute, he was called. He had to try a case and had to stay and said he'd be over on the next ship. The ship sailed and it got almost to England. It was struck by another ship and sank in a mere 12 minutes. Mr. Spafford got this telegram from his wife: "Saved alone." He knew that he'd lost his 4 daughters then. Immediately got on the next ship, and when he got on the ship, he told the captain of the ship, he said, "When we get to the point where the ship sank, where my little girls are, would you please tell me?" And the captain told me he would. So it was about 2 o'clock in the morning, a knock on his door, cabin door. The captain came to him and said, "Mr. Spafford, we believe this is where the ship sank." So Mr. Spafford, he went out, had a pencil and a piece of paper. He went to the foredeck of the ship, and he stood there knowing that he would never be that close to his little girls again. He looked up to heaven. He got on his knees. He prayed to God. He got up, looked up to God again, and then he wrote this verse: "When peace like a river attendeth my way, when sorrows like sea billows roll, whatever my lot, thou hast taught me to say, it is well with my soul." That's the greatest lawyer I know in my life. The greatest lawyer I ever heard of. I sum it up with my favorite Bible verse, Micah 6:8. It says, "He has showed thee, O man, what is good, and what doth the Lord require of thee, but to do justice, and to love mercy, and to walk humbly with thy God." I'll leave that with you. Thank you so much for your attention.